I'm audible. I'm Taina Majid here, and it gives me immense pleasure to kickstart the CoE-IP MSH webinar series. This webinar series has been organized in conjunction of CoE-IP and MSH. CoE-IP, or Center of Excellence of IPR, set up by CDAC, provides specialized IPR-related services in ICT domain to academic institutions, scientific societies of deity, SMEs, startups, and independent inventors. MeitY Startup Hub, or MSH, established under the aegis of STPI under the umbrella of MeitY, has been mandated to promote innovation, creation of intellectual properties, and technology startups for the purpose of setting up a vibrant technology startup ecosystem. I now call upon Mr. Parimal Khare, Senior Program Manager, CoE-IP, to please address the gathering with opening remarks. Over to you, sir.
Thank you, Taina. And on behalf of CDAC and CoE-IP, I welcome all the participants for this first initiative, first webinar with CoE-IP along with the MSH. So just to give a little brief about the CoE-IP, the Center for Excellence in Intellectual Property, which been working for last about 10 years in this areas. And CoE-IP was formulated in synchronized with the efforts of the government to sensitize the handhold domestic files, especially small business, to help them understand IP and become a part of a global IPR culture. From the humble beginning to its growing structure as a platform with the user base more than 20,000 professionals from ICT sphere, the CoE-IP journey has been formulated and foundational. Right now, the CoE-IP has its evolved with its bouquet of service was a step in the right direction, and now we are now coming up with a platform and services to face up to the current trends. So we started with the prior art searches initially for the innovators in the ICT domain, but now from that area, now we are moving towards the commercialization, and we have been initiating various services to facilitate the whole IPR regime in this domain. I hope that this series, which we are planning to start, we are looking forward to conduct various webinars, mostly focusing on to overall IP strategies, IP ownership. Apart from that, the IPR and venture fundings, monetization of IP or IP management for that matter. Of course, the patents, copyright, trade secrets, trademarks are going to be a part of our journey. But apart from that, we'll be focusing more on IP for emerging technology. And one more thing which we've been identified to do is we are coming up with we identify rather 52 different areas, technical areas, in which we are planning to start with the technology landscape reports. And I hope that such kind of a report will definitely help for the newcomers or new startups to identify the areas to work with. So with that, actually, rather to conclude, this webinar and is another effort on CoE-IP's part to bring together the startup and R&D communities on a single platform. This is our first initiative. We are looking forward to have 40 more to come in this journey, and I hope this definitely will help to all the startups regime. With that, I would like to thank you, Taina, and the team, and you can take it ahead, Taina. Thank you.
Thank you, Parimal sir. I now request Dr. A.K. Garg, Senior Director, Innovation IPR Division, MeitY, to please give a few remarks as Honorable Guest of Honor. Over to you, sir.
Thank you, Tanya. Thank you, CDAC and MSH, for this lovely initiative of yours. MeitY has been going through a journey on supporting the deep tech startup ecosystem in a very strong way, and MSH is playing a very stellar role in that, where it is trying to bring all the necessary ecosystems as part of the support to the deep tech startups. And IPR happens to be one of them. Uh, and I appreciate this initiative of the Center of Excellence on IPR as well as MSH for this webinar series. I hope the startup community will benefit a lot out of this, and I'll welcome whatever support you require on the IPR front. You look forward to MSH and CoE-IP as the platform to address many of those issues, which I know as entrepreneurs are very, very challenging in the coming times. Why I say so is that with whatever little experience I have with the deep tech startup ecosystem, what I've understood that India has now moved from being a mere services digital ecosystem to a system where the deep tech IP based products are becoming core of entrepreneurship. And if IP based deep tech ecosystem is emerging, IPR will be the necessary nuisance to handle the leveraging economic benefits out of such systems. And we need to have the necessary wherewith to handle such issues. I know most of the small companies and the startups will not have necessary internal um, mechanisms to address these issues. So the Center of Excellence on IPR has been created specific to the purpose that the small businesses and small startups can actually be handholded in their journey towards creating an IP, creating an IP by not infringing on others' IP, as well as whatever IP is created is protected in a way that they do not face challenges when they go to the market. And that's a very, very necessary thing to do if you are actually looking at Indian markets as well as looking at overseas markets. IPR now is actually, when we are talking about emerging technologies, when you're talking about adaptive manufacturing, when you're talking about artificial intelligence, when you are talking about blockchains and other such technologies, has now actually has this new set of challenges as compared to the old age world of trademarks, patents, and copyrights, which used to be the platforms. Now, protecting data, ownership of data, ownership of the platforms itself or the products itself, and ownership of new platforms or technologies created will be the new set of challenges that will emerge in the coming domain. An AI solution built through a machine, is it owned by the machine? Is it owned by the person who has licensed that software to create that solution? Or is it owned by the person who has actually created that platform that ultimately creates the solution? Are issues which needs to be resolved in coming days. Data ownership cannot be merely addressed through copyright laws, and they need a lot more thinking that has to go into it. So this not only the startup community has a challenge to look forward to, we as the Center of Excellence on IPR also need to find new solutions and provide them to the community as such. So the challenge is mutual, the journey is mutual, and we have to look forward to live to that expectations of the nation, to where we talk about an Atmanirbhar Bharat, a self-reliant India, where we become the technology leaders of tomorrow. If technology is there to solve problems for most of the sectors of economy, and we have the necessary challenges that are there to be addressed, and we most of our startups are addressing them, then we have the wherewith to convert those opportunities into economic benefit, and whatever is required on the IPR front has to be done. MeitY on its part has been in the IPR support system for long, but with the emergence of MeitY Startup Hub has actually matured it out into a targeted benefit based mechanism, and we are looking to address it. And then I like to seek your views that how better can the CoE-IP can support in your endeavor to create IP-based businesses. We have been running a very successful scheme on support for international patents in electronics and IT for a number of years, where we reimburse 50% of the total filing cost to a tune of 15 lakh rupees per patent for filing international patents, specifically for our IT sector, which has global market as its targeted audience. The Center of Excellence on IPR has been providing a number of services, including a prior art search, including opinions on IPRs, including your journey towards sensitization and knowledge on IPRs, which is a very techno-legal complex issue, has to be very sensitively handled. And I know we have the necessary manpower and expertise existing in CoE-IP. And now with this webinar series or a mutual interactive series that we have evolved, I think we will be able to take your targeted targeted queries and take it. I wish all the best for this webinar series. Look forward to a very interactive session for today. Thank you, Siddharth.
Thank you, sir. Thank you, Dr. Garg. So we now open the technical sessions. Our topic of discussion for today is IP strategies to drive startup success. To introduce our first speaker, Mr. Sudarshan Kumar Bansal. Sir is Senior Partner, United IPR, with expertise in IPR litigation, prosecution, and enforcement, to name a few. Over to you, sir.
Thank you, Tanya, and welcome to all, and thank you for inviting me. Intellectual property rights is not a challenge. It is a choice, and if intelligently made, it can be the difference between a successful business and a business that will have to struggle a lot. Startups are a part of our economic policy. Startups are what India needs. Or to put it simply, startups are India's future. Now, if any business is to start, the first and the most critical aspect of the business is, like the identity of the business, when you've selected the business as to what is the business you're going to do. Simultaneously with the business that you do, you will name that business with something. And intellectual property rights begin from the time when you have selected your business. Having regard to the business, the kind of intellectual property rights is what is critical. So the first and the foremost strategy is to select the IP and the right kind of IP for your business. The identity of the IP right is fundamental, and broadly speaking, IP rights on the basis of a startup, on the basis of an average startup, we can say, encompasses at least 4 types of rights amongst many. Number one, to begin with, as I said, the moment the business starts, a name has to be given to that firm or to that business and to the product or the service that it sells. So that name is what we protect as trademarks. Thereafter, having regard to the business, the other kind of rights would come in. But I would just categorize them for the sake of ease into 4 broad categories. Number 1 are trademarks. Number 2 are copyrights. Number 3 are designs. And number 4 are patents. So all of them are interrelated. None of them are standalone. But at the same time, the differences between these kind of rights is also very critical, because you have to register them, you have to enforce them, and to protect them. So the protection incidences are entirely different for all these 4 rights, even though they are overlapping. To put it broadly, a trademark is a symbol of origin. It is a name by which a particular business or a particular product is known or as referred to as. Copyrights, as the very name suggests, deals with literary works, artworks, cinematographic works, music works, etc. Designs deal with shapes and configurations visible to the eye, the external shapes and configurations of the product. And the patent deals with the engineering of the product, something that goes into it, the functionality of the product. And So within this 4 parameters is where you have to start identify and you have to go forward. All these four aspects of IP rights are governed by 4 different statutes: the Trademarks Act 1999, the Copyright Act 57, Designs Act 2000, Patent Act of 1970, and so on. So everything has to be found within these statutes, and accordingly registration has to be made, or an enforcement by way of a civil action or a criminal action has to be undertaken. So the identity of the kind of right is of fundamental importance. While selecting a trademark, the kind of trademark that you select for your business is also a very critical decision. Trademarks can be of various types, but the best and the strongest trademarks are trademarks which are invented words, which are rare words, or which are fancy, arbitrary terms. The more nearer the word that will describe your business comes nearer to the nature of your business, the less protective it will become, and the more elements of secondary significance and acquired distinctiveness would be required to protect such a work. So the more it comes nearer to to describe the nature of your business, the more difficult it will become to protect. Similarly, copyrights do not protect ideas; they only protect expressions. The way the product, the way your idea has been expressed. So this expression, the tangible expression, is important. Whether it's an artwork, artworks can also be trademarks. Whether it's literary works, for example, softwares. The softwares fall under the category of literary works, which are protected. They must be originally literary works. Then cinematographic works, musical works, etc. Designs protect external features of shape and configuration. And designs and patents both are only civil remedies. There is no criminality attached to the violation of designs or to the violation of patents. But there is an interlink between designs and trademarks. For example, trademarks can also be shape marks. So we have to see where an intelligent decision would have to be made at the first instance as to where we put the right. Designs are protected only for 15 years, whereafter they open up to the public. Trademarks are rights in perpetuity. Every 10 years you can renew them. Copyright 60 years plus the lifetime of the author, and similarly patents is for 20 years. So if you want a right in perpetuity, it is better that you go under the trademarks. Even copyrights like artworks can be protected as trademarks, so you can do it that way. But the enforcement of copyrights is very easy compared to trademarks. Just a report with the police station at a sub-inspector level can set the criminal law in motion. While for criminal enforcement, has to go and take an opinion from the registrar of trademarks, not an officer, not below the rank of a DSP or police, superintendent of police. Of fundamental importance is that what does right
It appears that there's some issue with Mr. Bansal's network. Taina, I'm audible.
Yes,
Yes,
Gaurav.
yes.
Absolutely.
I believe he's back now, please.
Okay, I'm sorry we lost touch for a little while. So intellectual property rights, why do we have them at the first place, or why do we need them at the first place? Number one is that intellectual property rights give you a market access. Once you can access the market with your intellectual property rights, you have a trademark that belongs to you, you can exploit it fully and use it to your full capacity. Similarly with copyright, similarly with designs, and similarly with patents and other types of intellectual property rights. Now, having entered the market, you must have two things with you. That, of course, the intellectual property right is there is no doubt. But the intellectual property right must also be protected in some manner. Just to have a trademark is not enough. Just to have an artwork is not enough. Number one, when you enter it, there must be an application for registration or a registration that has been granted. So there is a statutory recognition for your right. Number two is, when you enter the market, you must ensure that you are not violating somebody else's intellectual property right. Because if you violate somebody else's intellectual property right, it's very easy to jump into the market. But having jumped into the market, and if you are found to be an infringer, or you're found to be passing off your goods and business as that of another, or have infringed or by a substantial reproduction of somebody else's copyrights or an existing patent, then through the court system or through the enforcement system, you will be just thrown out of the market itself. And all the investment money that you have made to come into the market would just go waste. So one must be sure on this as well. And number three, and the most important, and another important aspect of the intellectual property right is that having entered the market, the right gives you a right to exclude others from the market. So it's a positive right to you that you can enter the market, exploit your intellectual property rights to your maximum benefit by numerous ways. Mr. Gogia, my senior associate and a very distinguished lawyer litigator, will give you more insights into these aspects. But once you enter the market, exploit your IP rights to the maximum. The exploitation can be done by your positive acts, when you're giving a good product, you're giving a product which is of value, and the product ultimately gets recognized by your IP rights. For example, if you go and buy a product which has a very well established brand and name attached to it, you'll always be sure that the product that you buy, even though you may not be aware of engineering, you may not be aware of the person who manufactures it, or even the source of the product, from which factory it comes, how it comes, etc. But nevertheless, the brand itself speaks for itself. So you know that a product under a particular brand itself would be a guarantee of a certain or your high price. So not to exclude somebody else. No, if there are a number of players in the market, of course, there'll be more products. You'll have to really struggle to make a place for yourself. But if you have a strong IP rights system backing your business, you can exclude people out. Exclude them out by the way, if they're infringing your rights, if they're passing off their goods and business as yours, then through court, through successful enforcement actions, you can actually remove those people from the market. So the space that is created by the removal of such infringing businesses or violent businesses, would be a space that you can occupy. So it will increase your sales, it will increase your business, it will give you this now on how to commercialize the IP, etc. I would request Mr. Gogia, my senior associate, a very strong litigator, a person with a distinguished R&D, and who has serviced many important industries and who has guided many startups in various aspects of their business. And I would request him to please take over from me, and with a request to Mr. Gogia that please give an insight of how the IP can be best used, specialized, and various other aspects of the IP. Please, Mr. Gogia.
To introduce Mr. Gogia, he is Principal Associate, United IPR, and currently spearheading the enforcement of IP rights at various brands with the Indian Customs and other entities. Over to you, Mr. Gogia.
Thank you, Diana. Thank you, Sudarshan sir. And thanks to CDAC and to MeitY for this platform. Diana, how much time do I have so that I can decide whether to share the presentation or whether to go extempore for 5 minutes? Then I'd like to just go extempore. But if I have, let's say, more than 10 minutes, then I would like to avail the opportunity to share my presentation.
Yes, I think about 10 minutes. Yes, please.
All right, thank you. So I'll be sharing my presentation where I'll stick to very crisp do's and don'ts for the startups. Is my screen visible? Diana, can you please confirm if my screen is visible?
Yes, it is. Gaurav, if you could put it on slideshow mode, please.
All right. So starting with infringement of IP rights, I have been addressing to Taina as Tanya all this while. I just realized I was not pronouncing the name correctly, because the first glimpse of her name gave me an impression that it's Tanya, because that's a more familiar name. Taina it's a unique one. So had it been a brand, had Tanya been a brand, and if I was a startup and inspired by Tanya, if I would have just kept Taina, regardless of whether Taina has a meaning as a word or not, I would have caused infringement. So this is the power of IP. What's in the name? What's said by William Shakespeare, and then he had his name under it. So there's another theory that everything is in the name. Today, the intangible properties, the intangible assets of any companies are the strongest assets. If you look at the world's most expensive company in terms of its valuation, or the world's richest man, we're talking about Jeff Bezos and Amazon respectively. So what do they have? Is Amazon a multi-billion dollar building? No, it is a brand which has value in terms of its IP. So that is the power of IP, and that is what we need to realize and protect from the word go. On my slide, if you see, there's a man who feels that he's created a new invention, and he rushes up to his friends or colleagues and he says, hey, I have a new product in hand, and it looks like, I've invented something. Here's my new invention. But he was surprised to see that, this is not something that is actually an invention, because it is something that his colleagues or friends also had. And there's a box which is filled with such stuff. So what looks like an invention to you perhaps may not be an invention in true sense. So whenever you are starting a business, as a startup, you need to make sure, if you're a tech startup, are we creating an invention which according to us is an invention, but it's indeed something which has been existing in the market? Or if it's not in the market, is there an application for that particular invention filed by some other company or some other inventor? Now, how do we do that? Now, this is what we'll discuss in this presentation. And I would like to briefly share an illustration of a mobile phone. This is an iPhone in this case. So in one single phone, we have 4 different types, in fact, 5 of them, 5 different types of IP rights in one single phone. And each IP right gives access to the owner for a limited period of time, or for a limited subject matter. If you can see on the top, we have integrated circuit, but the 4 most common IP rights, which Mr. Bansal also highlighted, we have something called as patented component. So basically, some process or some new invention, something that is novel, something that is not obvious, which was invented by iPhone. It could be a feature of the phone which nobody else has, but it's privy only to iPhone. It could be a feature by way of which you can make calls. It could be a feature for scrolling. It could be a feature for accessing to your contacts, etc. So any new technology which Apple has brought in, it could file patents for it. There was a very famous dispute between Apple and Samsung, which went into multi-billion dollars, and in different jurisdictions, different entities won. And there were millions of dollars in damages which were awarded in different jurisdictions as per their own laws. So patents are territorial in nature. So once you have filed your invention in India as a patent, it does not entitle you to protect your patent in other countries also. You need to file your applications in other countries as well to claim patent protection. And you can, of course, select the common jurisdictions where you want to have where you want to commercialize your your product, your IP, and consequently you can file those applications in a specified period of time if you want to claim parity with the Indian patent application. There are different routes which are available to file this application, which I will not go into much detail, but identifying which territories, which jurisdictions you want to operate in, and then accordingly beginning to file your application is something that I would definitely recommend. But before all of this, you need to identify whether something that you have created even qualifies as a patent. For that, you would have to have some expert opinion, usually a law firm who will look into, who will do a research for you based on the databases, some various software databases which it has. There are many paid and some open-end software databases also, which you can access to for the purpose of understanding whether your invention is actually an invention or whether it is something which is already either in public domain or sought as an invention by some other applicant. Next is the literary, musical, artistic work. All of it is again a subject matter of copyright. Whatever text or WhatsApps you are receiving forms, they're all literary work. They can be subject matter of copyright. The songs which you hear in your phone, the musical work, it constitutes of copyright as well. In one single song also, there are multiple rights which are created. For example, the singer has the right to its dramatic work. The author has the right to literary work. Likewise, the composer has the right to musical work. Then the entity which was responsible for recording the sound, it could be T-Series, Saregama, whatever. They have the rights in the sound recording. So there are broadly 6 types of copyrights, broadly 6 types of works in which copyrights prevail. The artistic work, literary work, dramatic work. Dramatic is the singer who's singing or the performer who's performing. Musical work, cinematography, and sound recording. These are the 6 types of works which qualify for copyright broadly. Then we come to the trademark. As Sudarshan sir rightly mentioned, we have brands, logos, symbols, and these days we have moved much beyond these conventional trademarks. We have color combinations as trademarks. We have shapes as trademarks. We have sounds as trademarks. The Nokia ringtone, the Apple ringtone, Xiaomi ringtone. All these phones have a unique ringtone, and the moment you hear to those ringtones, you know which brand of phone is ringing. So that is a sound trademark. You can recognize the brand by simply hearing it. Then you have a shape trademark where you can identify the source or origin of a product by merely looking at it, by merely looking at the shape of the product. Then you have color combinations as trademarks where you recognize a particular scheme of colors. For example, if you see a toothpaste in red and white color, the first impression in your head is that it's a Colgate product. For example, if you see olive oil in a dark olive green color with the golden combination, you would believe it to be a Figaro olive oil. Likewise, there could be several such color combinations in which there are rights belonging to particular companies. But all these rights are created by virtue of substantial use and goodwill. These marks are not inherently distinctive. As Sir rightly mentioned, you need to create something which is yours, which is inherently unique and distinctive, arbitrary, fancy, rare, coined. So unless you are creating something that is unique, you are likely to infringe on someone else's rights. So it should not be basically descriptive of your products. Today, if I'm keeping Fair and Lovely for fairness cream, it is not a very good trademark, even though it is a registered trademark because it has acquired distinctiveness. But I would call it a very bad trademark. There are several such trademarks. Real for juices is a suggestive mark that the juice is real. It's not made of pulp or it's not made of artificial flavors, which in fact is not the case. But if you are keeping something arbitrary, Panasonic, Kodak, Aiwa, Nikon, a lot of these Japanese brands are very unique. There could be some other Crocs for footwear, Nike for footwear, L'Oreal for your cosmetics. These are all very unique names which have no relation to the goods. Now, there could be some brands like Mango for apparel is very arbitrary, but Mango for mango juice would have been descriptive. Fruity for juice is unique. Apple for mobile phones is a very arbitrary and unique mark. Likewise, a crocodile for a t-shirt. So the point is, when you're keeping a brand, make sure it is unique and distinctive and not already in public domain. Now, how do you find whether a brand which you have kept is already in public domain? Of course, you cannot keep something that is already there or which is identical with or deceptively similar to something that is already existing in the market. So if let's say there is an Apple logo that I can see here, and what I do is I create another logo which has a cut on the side or on the top or on the other side. And I instead of Apple, I change the spellings to A-P-L-E. I remove one P. And I try to create something that is of my own, but indeed it is not. So there is a very fine line of distinction between inspiration and infringement. And we need to be cautious that if you are being inspired by something, we don't cross that line to cause infringement. And for that, there's a public search that we can do on the website of the IP India. We need to find out whether there is a mark which is prior existing, whether a mark is available. That will come under the freedom to operate part. I will discuss that with you as well. And then is the unique shape of the product, the shape of mobile phone. Every car has a very unique shape. So you can identify the cars even without looking at what brand it is. Why? Because they have a unique design to it. Design is something that is aesthetic, which is visually appealing, which has an ornamental value to it. So every design which is new, unique, can be protected as an industrial design. Now, the interesting part is you must have seen some Coca-Cola bottles used to have some design number on them. Even the Bisleri bottles has some design number on the top of the cap or on the bottom of the bottle. But that was not on all the products. On a very peculiar shape of bottle, and only for a limited period of time. Why? Because design rights are available to the right holder only for a period of 10 years, extended by a period of 5 years. After 15 years, that design comes into public domain. For patent also, how to commercialize your patent becomes very important, because when you file the patent and by the time you are granted it, you are already maybe 3 to 4 years into the system. So let's say in 3 to 4 years time, you are granted patent. So ideally, the time within which you can monetize and commercialize your patented technology is about 15 years, because the maximum duration of a patent is 10 years, extendable for a further period of 1 year up to 10 years. So total life of patent cannot exceed 20 years. After that, the invention has to come to the public domain and anybody and everybody is free to use it. The copyright likewise has a duration of 60 years after the life of author for most of the works. Trademark is one unique right where, which does not die, so to say, because if you see Ford is a 1857 brand. There are brands which are even since 1900 and old. So the brand does not die. So long as the brand is being renewed within time to time. Since 2003, September, a brand can be renewed for 10 years, every 10 years. And that period of 10 years can go on indefinitely. So you can renew your brand every 10 years, and you also have to make sure that you are using the brand. So Nokia was not using its brand for a while, and it became vulnerable for cancellation. Then it again entered the market. The Finnish brand Nokia was about to lose its significance, but then it entered the market again. Now I'll share with you some do's and don'ts of the for startups. Number one is you should not undervalue IP, not only your own IP, but also someone else's IP. Don't undervalue or undermine the importance of IP. IP ko baad mein dekh lenge. We've seen this attitude for startups. Many times they feel like, we will look into it at a later stage. Right now, we have budget constraints. So the government understands that you have budget constraints, and the government also understands that IP is very important for every business. So what it has done, it has provided a lot of schemes to startups under the Startup India initiative. Whenever you are filing your IP, there's a certain amount which you can claim as reimbursement to whatever expenditure you've incurred, be it for trademarks, designs, or for patents. So a lot of funding is provided to startups, a lot of incentives are provided to startups. So be aware of whatever incentives are available, whatever is offered by the government, so that you are not hesitant in investing in your IP at the very first stage. Because very recently, there was a case where we were approached by someone who had kept a brand Jalfina, and he was sued by PepsiCo and company because their trademark was Aquafina. Now, he was in a very difficult position because he had a startup business. He had no idea. He thought that Jalfina, I thought, was substantially distinguishable from Aquafina. It is not something that is even closely related to Aquafina. Jalfina is in Hindi. He was writing it in a very different font. He was not using the white and blue color combination also. But the trademark law does not allow you to do so. You cannot keep a mark which is either visually similar, or which is phonetically similar, or which is conceptually similar. Here, Jal and water had the same meaning. So conceptual similarity is also, or structural similarity is also not permissible under law. Because an ordinary or unwary consumer might have been deceived into believing that Aquafina has perhaps diversified for the Indian market and created another sub-brand of its own. So just to ensure that Jalfina is not trading upon Aquafina, the mark was not permitted by the court. Then not creating an IP strategy is a mistake that some startups can do. So when you do not undervalue your IP or do not undermine the importance of IP, you always create an IP strategy. To start with, you don't need to have a very exhaustive strategy, but at least for tech startups, you know that if you are using something in the market, are you infringing someone's patent? You would know whether what you are using is patented by someone. If you don't know, get it checked before using it, because you don't want to start a business and then later on, 2 years later, you receive a legal notice that you've by that time invested so much into your business that you are in a fix whether to discontinue my work, or whether to change my brand, or what to do then. So at that time, there will be a lot of inconvenience that can be caused, like what happened with Jalfina, where the startup, it had made a lot of investment into the printing of bottles, so it had to scrap all of that. Not keeping the creators of their IP in communication with the decision maker. So this is also important. When whosoever you are hiring for creating your logo, or whosoever you are hiring to devise your patent, or to share their insight on the technology part, you have to be transparent and have a written mode of correspondence with them, either through WhatsApp or through emails. Of course, emails are more preferred way of correspondence. Have it very crystal clear. Avoid writing 1 or 2 liners. Make it very clear what you intend to say, what is it that you intend to protect. Have non-disclosure agreements with the creators of your IP. If you have hired someone to create something and you've paid adequately to them as per their contract, then ideally the work belongs to you, but it's better to have a non-disclosure agreement with such creator of IP. We many times use the services of specialized web designers or specialized third-party agencies who create our website, who create our logos. It is better to have a short template, one-pager agreement that, please sign this agreement, which will restrain them from claiming any right in the creation of that website or logo at a later stage. Not protecting confidentiality. So this is also a mistake that you can do if you feel that your IP, if your invention, it's so unique, which cannot be reverse engineered. Now, I'll give you some examples. Coca-Cola has been very confident from the word go that the formula which they are using is very special for a cola drink. Now, if we taste hundreds of cola drink in the market, Coca-Cola still has a very unique taste which we can recognize with our eyes closed. And it has been reverse engineered and so many times, but exact formulation is known only to 2 people within the company who created it. So that has never been disclosed. That has remained as a trade secret. When I file a patent, I have to disclose everything. So it is a very good decision of whether to keep something as a trade secret or whether to disclose it from the very word go, so that you are claiming your rights there and then. Okay, this is my invention. This is something I've created and I want to protect it. There are very rare instances of trade secrets, especially in US, where they have a proper law. In India, we don't have a statute which protects trade secrets. Trade secrets in India is governed by contracts law. So if I have a contractual obligation with someone, that is the only way I can ensure, which is why an NDA becomes very important. NDA means a non-disclosure agreement, becomes very important. It contains some confidentiality clauses. But otherwise, not everyone can be like Coca-Cola or KFC. It has a unique formula for its fried chicken. Then WD-40, again, an American company, has a unique formula for its water displacement and anti-rust, anti-lubricant spray. So there are many such companies in US who have created their inventions as trade secrets. But in India, we are better off seeking it as a patent, because that is what is protected in India. Choosing a common word for the brand name or trademark in place of a fanciful. This is a mistake. I will not repeat this. You should have something. If I should not be keeping something as Tanya, as I mentioned, because sorry, Taina, I should not be keeping something like that. Not conducting a trademark search on the databases is also a mistake that I might do, which is something I should avoid. Taina, how much more time do I have? Because the presentation is quite big. We have licensing, we have a freedom to operate, and these are important concepts. So can I take another 2 to 4 minutes?
Yes, please.
Thank you so much. So licensing, again, is a very crucial aspect of IP. What do you understand by licensing? Licensing means when we have authorized a third party to use our rights. It is different from selling off your right or assigning your right. In order to use someone else's IP, let us say today you know that there's a particular technology on which ABC company has a patent, but you also know that without using that, in order to create your mobile phone, you would eventually require Snapdragon 855 processor or 875 processor to make a high-speed phone. So you will have to take their approval for using their product. You will have to get into an agreement if you want the products. It could be a franchisee agreement. If you want to create something like that, you need to have their approval. So when you enter into franchisee agreements for using the brand, these are called licensing agreements. They can be of two types broadly. Either you have exclusive rights. For example, I have good pockets and I know that I can cover the entire India market. So I reach out to Qualcomm in US and I say, in India, I have a huge manufacturing unit and I can cater to the market. I want exclusive license to make your product. So Qualcomm says, okay, you can have my exclusive license, but then the royalty amount, the fees charged by Qualcomm might be on the higher side. Alternatively, you can have a non-exclusive license agreement where Qualcomm would say, okay, I'll give you the right to use, but at the same time, I will also give some others, whoever comes to me, I can give them the right. You will not be the sole or the exclusive license holder for the Indian market. I can have more such licensees. So these are the two broad types of agreements, but you need to consider that even if it is a sole or exclusive license, that does not give you the proprietorship in the brand. That does not authorize to use the brand as your own. You cannot sublet that. You cannot allow someone else to use that on your behalf. You cannot, there are certain restrictions which will be imposed in that license agreement. First of all, it will contain a duration for maybe 5 years, 7 years, 11 years. Usually it is 9 to 11 years. So license is granted for a limited period of time, and it is conferring very limited rights for you to use that particular technology or for that particular branding. Under WIPO, WIPO means the World Intellectual Property Organization, to which India is substantially compliant under a TRIPS agreement. So WIPO has classified IP licenses either as a technology license agreement, which involves patents, franchisee, as I just mentioned, or a trademark license agreement, where you have the right to use their brand or their logo, tagline, anything, or the copyright license agreement, which you would see are usually executed by the singers, they give license to some music recording company or some production house who can use the song against which they receive royalty. So either I can license that, or I can use it, or I can sell it. I can assign my right also against a lump sum amount, or I can simply allow them to use it, and against whatever number of copies are sold, I can realize the royalty out of it. Copyright license agreement you must also come across whenever you are downloading the softwares of Microsoft or original softwares of Java, Adobe, so on and so forth. There's a copyright license agreement which is executed, which you agree to before using that particular software. This is something I've again discussed. And freedom to operate. What do we understand by the term freedom to operate? I've broadly covered this already in terms of concept, but a risk management tool that contemplates likelihood of infringement or litigation. So before I start my business, before I enter into a particular territory, I need to check whether my brand is available in the market, whether the company name which I have kept. So whenever you apply for a company name also, you have to give a list of preferences, 1, 2, 3, 4 in terms of the order of priority to the registrar of companies. And thereafter you are granted a company name. Likewise for the trademark also, you need to make sure that the brand which you are keeping for your products or services is not something that is already taken. So freedom to operate is conducted before entering into a particular territory or a particular area of business. It's a very exhaustive presentation which I have. I think I will just stop here. We have defending the right strategy also, which Sudarshan sir rightly discussed. If someone is using your IP, you can send a legal notice, which is called a cease and desist notice, or you can issue a takedown notice. Today we are living in an IT world, so you can issue a takedown request to someone. You can file a lawsuit if your brand or your IP is being infringed or being passed off. Taina, I think that the remaining part we can have during the Q&A. I'll be happy to address any questions which any of the audience may have.
Right. Yes. Thank you, Gaurav. Am I audible to everybody?
Yes, please.
So the floor is now open for Q&A, and please feel free to send in any queries through the chat as well, and we'll be happy to answer it. Okay, Gaurav, are you there? Yeah, for you. For starters, when we do talk of IP strategies that drive startup success, how would you, in the context, in the background of the pandemic, where the entire ecosystem for IPR and for tech startups has undergone, a paradigm shift, how would you sort of give your thoughts on your topic?
It has indeed been a concern. COVID-19 has impacted across the spectrum, and fortunately, we've been able to now live with it, to understand how to deal with it and how to overcome it. In the current scenario for startups, we are now depending a lot on online resources. So everything and anything which we are researching is available over the internet. It's available over the softwares and databases that we have. So for startups, tech startups in particular, there is nothing that can stop them from. In fact, this is the ideal time. This has given a lot of time to the startups, to the incubators, to sit back and spend, invest more time and more resources into understanding and evaluating the business strategies, having the risk analysis, and to see where they would stand in terms of the products or services. What has been impacted majorly is the nature of business or services, or the nature of goods or services which they propose to render. Now that is a business assessment which has to be done. Today, if I'm launching, let's say, an energy drink in the market, So it may not have as good an impact as opposed to something that is more nutritious. If I'm launching, instead of energy drink, if I propose to launch a product which has immunity boosting effect, so to say, that will have a better sale. So for startups, what they need to consider right now is what category of products, what category of goods and services which they wish to sell, which they wish to start with their business. For tech startups, also, it would be more of the amalgamation of various resources that they have, which they need to put together and understand the dynamics of the market and then come forward. From IP perspective, fortunately, we have become completely online. It is possible to file the applications online. The hearings are granted online. The court hearings are also granted online. So anything that is of urgent nature is being heard by the courts today. Likewise, the patent applications can also be filed seamlessly. The oppositions can be filed. The new trademark applications are also being filed.
Can I just add in something?
Please, sir.
See, thank you, Gogia, for giving this opportunity, and ma'am as well. See, under the pandemic situations, with vis-a-vis the IP rights, I mean, just point out, just in addition to what Mr. Gogia has pointed out, there has been no change in substantive law. The substantive law has remained the same. Now, what has the change has been that the way you would use those rights. So if you have to alter your business to address to a pandemic situation, for example, online, greater use of online resources, of course, a good startup or an intelligent engineer or entrepreneur can definitely do that. But what I can just say is that even if he does that, he or she does that, alter the business to take into the pandemic situations in mind, the IP rights are even available there. IP rights are not being lost out. It is only the way to use it, protect it, and enforce it may have changed with respect to pandemic situations. So that is one of the beauty of our IP laws, that they are always flexible to address many situations. But substantive law has not changed because of the pandemic. This is what I wanted to add. Yes.
Yes, sir. Very, very well said. Okay, so Mr. Gogia and Mr. Bansal, one more. There is a query where they run a sports tech startup and wish to know the process to get technology copyrighted. Do they have to apply for copyright to be eligible under the subsidy as patent?
See, is it for me or for Mr. Gogia?
Either of you.
Mr.
Either of you.
See, under the copyright law, registrations are not necessary. Unlike patents and designs, which can only be protected once your design or patent has been registered. Under the trademark law, registration gives additional remedy over and above, but it's an extension of the passing of principle, where registration is not necessary. Now, under the copyright law, registrations are not required at all. I mean, from a law, and copyright comes into existence the moment the work is created. But for evidentiary value, after all, once you go into the market, or you have to protect or enforce your marks, your artworks, literary works, cinematographic works, dramatic works, etc., sound recordings. I mean, having regard to the nature of your right. But registration becomes important because it serves as a very basic, a very important evidence. Now, under the copyright law, unlike patents and designs, two people can simultaneously, sitting in different places, create the same artwork. I mean, create the same copyright or similar copyright, and each will have its own independent rights. But which is not there available under the patent law and the designs law. Under the patent law, who creates it first or who files for it first wins, even if the second party had no access to his work. And it's an independent creation of the second party. But under the copyright law, the things are a little different. So when you have to enforce your right, then the issue as to who created the work first, not who filed it, that becomes important. And filing for the registration has an approval. There's a date, there's a stamp of the government of India, etc. So it serves as a very important evidence in enforcement and protection of your copyright, even though technically copyrights exist independently of registration. And registrations are not mandatory for you to enforce or protect your works. But under the practical evidentiary value in protection and enforcement, filings become very important.
Right, sir. So we'll just take one last question with your permission. So there is Mr. Dev who's written that we are an IT startup and how can we go for IPR depending upon existing 5G and edge server technology?
Mr. Gogia, would you like to answer? Mr. Gogia, you're mute.
I'm sorry. I was speaking all this while. So first of all, whether we are infringing any IP right is something we need to understand. Just because there is 5G, we need to first understand what is your technology, whether your launch of technology, whether it infringes some other technology, is a matter of subject matter of scrutiny, is a subject matter of detailed review and insight. So in view of 5G or in view of whatever technology that you are proposing to launch, you need to understand whether what is in existence has been patented, has been already patented or has been already being used by some other entity. That is something you need to be cautious with. Now, if your question is with respect to whether you are using 5G in your technology and whether would that be in line with the government compliances, that is something that the government will decide in due course. Because right now, the future of 5G still remains a little uncertain, even though at the moment it is allowed. There is no restriction on use of 5G so far. There's no clear restriction, but it may so happen that the government, upon receiving some PIL or some other consideration, if 5G is not permitted in future, then your technology automatically gets hampered. So whatever technology startup you are launching, it has to be not only in line with the IP laws, but also in line with the government rules and regulations which are framed under various statutes.
Right, Gaurav. I hope it answers the query. So, okay, so on this note, thank you both. Thank you, Mr. Bansal. Thank you, Mr. Gogia. I, as a concluding remark, would like to invite CEO, MeitY Startup Hub, Mr. Jitendra Vijayvargiya. Over to you, sir.
Thank you, Taina. Good evening, everyone, and special thanks to Sudarshan and Gaurav for the wonderful session that they conducted today on a short notice. As we heard, the only message I have for our startups is that IP. It's not just about protecting value; it's about building valuation. It's about not only competing in the market space today, but it's about competing in the opportunity space of tomorrow. It's about creating a footprint for the new India that we are building based on the intellect that we have today. So using our intellect today to carve out the innovation space tomorrow, in which we can fill it up with the hard resources and the capabilities that we have to create something. And of course, it's a very complicated topic and it's very difficult to make it engaging and exciting. But I think Sudarshanji and Gaurav have done a wonderful job of showing the various elements of intellectual property in terms of how it needs to be conceived, perceived, and implemented in the business plan. So I would request everyone to actually not look at IP as an afterthought when they're building a product or building a solution, but it should be viewed as a nucleus, a DNA of any innovation that we are conceiving and implementing, because around that only you can build the larger structure of the various products that you will build. So please take into consideration the domain of intellectual property as it pertains to your different innovations. And secondly, I'm sure Parimal and Anil would have discussed this with you, that at MeitY, at Ministry of Electronics and IT, at the Center of Excellence in Intellectual Property and CDAC, there's plenty of resources available for you guys that you can utilize, that you can take advantage of in terms of the opportunity for reimbursements, in terms of access to the intellectual resources for understanding IP, in terms of doing the prior art search, in terms of drafting and expertise that is needed. Because not only the expertise lie in-house with Anil and Parimalji, as they may have discussed, but it also lies in the network of relationships and the experts that they have curated for your benefit. So, it's people like Gaurav and Sudarshan who can be a mentor, who can be a service provider, who can be the experts that you can bounce off your ideas to understand what actually you need to do in terms of IP strategy. So without taking any more time, I really want to thank our speakers today and really appreciate this opportunity. And Taina, back to you with that.
Right. Thank you, Jeet. So on behalf of CoE-IP and MSH, I'd like to thank our esteemed speakers and United IPR for their relentless support. I thank our participants for taking out their valuable time today for joining in. And please don't forget, everyone, to follow CoE-IP and MSH on all our social media handles